I mean, just to take you back to the question that Justice Thomas started you with, I mean, it seems to me there are two choices here, and you could read this as otherwise obstructs a proceeding or otherwise spoils evidence. And you are using it to say otherwise spoils evidence with, spoils being all those verbs. But it doesn't say that. It says otherwise obstructs a proceeding. There are plenty of ways to write the statute that you want to write. You could just say otherwise affects the integrity or availability of evidence in an official proceeding. You could combine official proceeding with evidence in other ways. One with, you could replicate the mens rea that C1 has. I mean, there are ways in which C2, multiple ways in which the drafters of C2 could have made it clear that they intended C2 to also operate only in the sphere of evidence spoliation. But it doesn't do that. All it says is otherwise obstructs, influences, or impedes.
Certainly the statute could be written more precisely. Any statute could be written more precisely.
Well, it's not a question of precisely. The question is, what is this otherwise? This is what Justice Thomas said at the beginning. What is this otherwise taking from C1? Of course, there's commonality that's involved in an otherwise. There's both commonality and difference. But what is the commonality that C2 is drawing from C1? It tells you what the commonality is. The commonality is that the things that fall into C2 also have to obstruct, influence, or impede. But what C2 does not say, really does not say, is everything in C2 also has to spoil evidence.
But this court has said that otherwise in a criminal statute means similar conduct.
Similar conduct, obstruction of a proceeding, different ways of carrying out that similar conduct, which is obstruction of a proceeding. The statute tells you what the similar conduct is right on its face.
It's Michael Popok, and I'm back with an update on the United States Supreme Court case I talked to you about last week, Fischer versus the United States, which has implications for Donald Trump, his prosecution by the special counsel, and 350 other Jan 6 defendants. Because if the United States Supreme Court finds that a particular statute used by the prosecutors as part of their indictment, 18 U.S.C. 1512C, obstruction of an official proceeding, doesn't fit the crime, is being improperly overcharged by the prosecutors, 350 people who were already convicted can ask to have their sentences vacated, be resentenced, retried, and the rest. And for Donald Trump, it would lay the groundwork for Donald Trump to move to dismiss at least 2 of the 4 counts in the D.C. election interference case in front of Judge Chutkan, make his argument, have the special counsel argue on the other side that even if the Supreme Court finds that for the Jan 6 defendants on the ground who, as insurrectionists, tried to stop the official count of the certification of the electoral votes, it still applies to Donald Trump because there was a mutilation, alteration of evidence, in this case, the use of false elector certificates, which even under this Supreme Court's ultimate decision, should it go against the Department of Justice, would still be in play for Donald Trump. I mean, that would be the analysis, but that would delay things inevitably in the DC election interference case. Right at the moment, it may be back up and running by the end of the summer if the Supreme Court votes in favor of the Department of Justice in the immunity hearing, which is in 9 more days. Confused you won't be by the end of this particular hot take. Let me explain. What are we talking about? We have a guy named Joe Fischer, used to be a cop in Pennsylvania. He was charged along with about 350 other Jan 6th insurrectionists of the few thousand that attacked the Capitol with one of the highest counts other than seditious conspiracy used by the Department of Justice. It's a law on the books since 2002, brought there by the Sarbanes-Oxley 2002 criminal justice reform. It was mainly addressed for financial fraud, like Enron, you might have heard of, a phony company that went down in flames, that brought down in flames Arthur Andersen, which had been a 150-year-old accounting firm, because of the destruction of evidence, yes. what the argument for Joe Fischer at the Supreme Court level, and that was adopted by the trial judge, but not the appellate court right below the Supreme Court. The argument was you can only use 18 USC 1512C, a complicated way to talk about that statute, if there is the actual alteration or destruction of physical evidence. In other words, Joe Fischer would have to have been charged and indicted and convicted of ripping up, as the trial judge, Judge Nichols, said, ripping up the certificates. And he didn't do that, of course. Let's put Donald Trump in a separate category. We should always put Donald Trump in a separate category. Twice impeached, 91 times felony indicted, that kind of category. And the charges against him are different than the Jan 6 defendants who were there doing his bidding after he fomented them on Jan 6. Now, look. If Joe Fischer is right, and I'm going to tell you that it was a divided bench today in oral argument. You heard at the beginning of my hot take, Justice Kagan framing the issue for those that could vote to have this count survive the attack by Joe Fischer and be used by the Justice Department and have all of those 350 people already convicted of this or soon to be convicted of it have their sentences stand. The argument is a little bit of an arcane and academic one, but I'm going to break it down for you here. There's two parts to the statute. There, as you heard Justice Kagan talk about it, there is subsection A and subsection B. So on the first part of it, it talks about 1512 C1. It talks about the alteration, mutilation, destruction, hiding of documents and information. But the second part, subsection 2, says or otherwise obstructs an official proceeding. An official proceeding can be the congressional attempt to certify the election. It can be a court proceeding. It can be an investigation. It could be anything. And so the argument for Joe Fischer is that the word otherwise means it has to be similar to, he translates that into similar. It has to be similar to mutilating, destroying evidence. And since there's no mutilation or destruction of evidence in this case, it can't be used as the crime. The counter argument raised by the Solicitor General for the United States, arguing for the United States, Liz Proliger, she argued that's not what the statute says. The statute says otherwise impedes or impairs an official proceeding. If Congress wanted to limit it to only if you do it in ways like ripping up evidence, they would have said that, but they didn't say that. But I'll tell you straight, from the way the justices were arguing, Alito is going to vote against this particular crime being used against the Jan 6 defendants and probably against Trump down the road. Gorsuch didn't like the broad sweep. I think one of them called it a dragnet, dragging everybody into its reach, which I don't think is appropriate. I think anybody reading it in English under Webster's definitions would think that otherwise was a catch-all to be used as further defined by the first part of 1512C. Thomas, Alito, Gorsuch, and even Roberts seemed to be struggling with the full reach of it. Although at the end, Roberts, in the oral argument, which lasted about an hour and 25 minutes, I mean, these 30-minute oral arguments are going a long time here with this particular lineup of justices. Roberts, I think, could be swayed back to the fact that this statute, the way it's written, does have limits within it. So it's not this broad, overarching dragnet. And it isn't overly broad in catching all behavior in its reach, but has certain defined limitations that can be applied. Roberts is going to be the key to it. So let's assume the lineup after this oral argument and then the caucus and the voting about, are they going to vote thumbs up or thumbs down? And the issue is whether the D.C. Court of Appeals and the 3-judge panel there got it right or wrong, led again by Judge Pan, the same judge who they're going to be evaluating on the 25th of April about the immunity issue. She led that panel as well. Whether Judge Pan got it right that this statute can apply to the actions of the Jan 6 defendants, putting aside Trump for a minute. I promise I'll get there on this hot take. Now, if it's Roberts, All right. Then it would be Roberts, Sotomayor, Kagan, who you heard from at the top of my hot take, and Amy and Ketanji Brown Jackson. That would give 1, 2, 3, 4 were short one, right? And the one would have to come from Amy Coney Barrett or Kavanaugh, who kept their cards very close to their vest today during oral argument. We don't know where they sit. And so right now it is a divided court. This could go 5-4, I think, either way. Now that would impact definitely, immediately, the 350 people other than Joe Fischer who got indicted for 18 USC 1512C and were convicted and or sentenced under it. They're all going to have those decisions, their sentencing, their convictions vacated. If they haven't been tried yet, it'll be removed from their indictment. Maybe if that was their only charge, they'll be released. Now let's talk about Donald Trump for a minute. As the government laid out, Jack Smith laid out in a brief he's filed in the immunity case, it doesn't matter whether those two counts are the same 18 USC 1512C, because as alleged in the indictment, there is an alteration, destruction of a document or evidence, and that is the use of the false elector certificates, which was not present with the other 350 Jan 6 defendants. So Jack Smith kind of saving moment in the brief that was just filed at the United States Supreme Court to get ready for the April 25th oral argument, which we'll also report to you on here on Legal AF and on MeidasTouch, was that it doesn't matter what happens to those Jan 6 defendants. That count still applies to Donald Trump, even under a more strict, narrow interpretation, if that's what the Supreme Court does, because we do have destruction, alteration, and mutilation of documents in this case. And that is because there was a phony fake elector certificate attempted to be used that Donald Trump used as part of the conspiracy that he orchestrated. That's their argument. Now, what's going to happen in real life, and that's why I wanted to save it for last, is that if the Supreme Court flips 5-4 and strikes this as being part of the indictments for Jan 6 defendants, you know the lawyers in the Chutkan case for Donald Trump, right? John Lauro and Todd Blanche, whoever's defending Donald Trump at the moment, it's like a flavor of the week. If that case gets back up and running, because and this is a couple of ifs here, right? Couple of things have to fall into place. It's like a playoff scenario for football. Couple of things have to happen in order for what I'm about to tell you to work. The Supreme Court, after oral argument on the immunity issue, would have to find a month or so later that Donald Trump does not, as a former president, have immunity for the things that have been charged in the indictment in the D.C. election interference case, send it back with a mandate to Judge Chutkan, who's the trial judge. She would then hold an immediate hearing, bring the lawyers back in. She's already said she's going to add 90 days to preparation time for Donald Trump, depending upon where he is in the election interference case up in New York, because that case is still going to be going on, probably when she's holding that hearing. And then she's going to pick some date in August, maybe September, to start her trial. They're going to inform the lawyers for Donald Trump, Judge Chutkan, that they're planning to move to dismiss based on the new precedent of U.S. versus Fischer, if it goes in their direction, the counts under 1512C. The judge will have to have full briefing on that, oral argument on that, and make a ruling on that. And the loser of that will likely, especially if it's Trump, try to take it up on appeal to the Court of Appeals for the D.C. Circuit, and then up to the United States Supreme Court. The reality is that unless at that moment Jack Smith decides to cut fish and cut bait and get rid of those two counts and just try the other conspiracy counts against Donald Trump, that case, based on this Supreme Court decision going against the Department of Justice ultimately, will be delayed further, and it won't be tried before November the 5th. Meaning the only case likely that will be tried before November the 5th is the one that's already started up in New York, the election interference business fraud case. That's where we are. I did it. I covered it all. How many minutes was that? In 12 minutes or less, I covered it. One place on the MeidasTouch Network and on Legal AF right here. If you like what I do, you can go over to playlists on the YouTube channel for MeidasTouch, and you can look for Michael Popok. I'm under contributors, I'm under playlists, under my name, and all that. You'll see like 1,200 of these kind of hot takes. And if you really like what we're doing, you want to get down to the molecular level and learn the law, procedure, criminal, state, constitutional, civil law, and all of that, then we do that And you can take the building blocks of that over to our Hot Takes and Legal AF, our podcast, on Patreon with exclusive content you can only get there and you can't get anywhere else. It's at patreon.com/legalaf. You can geek out with us there. It's made for the non-lawyer and lawyer alike. So it'll be informative, but hopefully entertaining, sort of like my hot takes. So until my next hot take, until my next Legal AF podcast, until my next Patreon exclusive content, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.